The questions of this bill will be now read a second time, and I'll give the call to the Parliamentary Secretary to the Minister for Industry and the member for Paterson.
Well, thank you, Deputy Speaker, and I'd like to thank my colleagues in this House for their very wide-ranging contributions to this debate. Many of the contribution, of course, not focusing on the bill before them at this point in time. I'd also like to thank the New Zealand Government, in particular the Ministry of Business, Innovation and Employment and the Intellectual Property Office in New Zealand for its cooperation in the development of the trans-Tasman provisions of this bill. I'd also like to thank the many industry stakeholders who contributed to the development of this bill. The proposed legislation has been the subject of extensive consultation over recent years. The proposed legislation will reduce a number of barriers and regulatory costs for Australian businesses using the intellectual property system. Deputy Speaker, introducing a trans-Tasman patent attorney regime and patent applications examination process will reduce costs for businesses operating in both countries. Implementing the TRIPS protocol will allow Australian manufacturers of generic pharmaceuticals to provide assistance to developing countries. The Howard government accepted the terms of the protocol in 2007, and the Abbott government is now delivering on this important change. Enabling the owners of plant breeders' rights to use the Federal Circuit Court will give them faster and, more in particular, a more cost-effective way to protect their rights. Deputy Speaker, repealing unnecessary provisions on the storage of documents will reduce warehousing costs and increase efficiencies. This bill is designed to reduce red tape, which has been one of the hallmarks of this coalition government. I'd like to respond now to a few of the points that have been raised by my colleagues in this House. As pointed out by many members of the opposition, in 2013, the former Labor government attempted to make changes to Crown use provisions of the Patents Act 1990. Now, I understand these changes were in response to recommendations made by the Productivity Commission following its inquiry into compulsory licensing. At the time, these amendments were introduced into the Parliament on the 30th of May last year, just 3 days after the Productivity Commission had publicly released its final report. It was readily apparent to anyone that the Labor government had not adequately considered or consulted on these measures. Deputy Speaker, things like this should not be rushed through the Parliament. You need to take people on the journey with you, Deputy Speaker, both politicians, professionals and industry alike. Both industry stakeholders and members of Parliament were concerned that the amendments were rushed, lacked detailed consideration, and thankfully, Deputy Speaker, these changes were not passed by the Parliament. Deputy Speaker, I acknowledge how important the Crown use provisions are. We acknowledge that. The government has not progressed any related amendments at this stage, as further detailed consideration and consultation is necessary. Now, I note that the member for Melbourne has an amendment that he intends to put in relation to bringing Crown use provisions as a part of this bill. But again, where has the consultation been? This is a rushed effort, and the first we've heard about this intention was tonight. Well, Deputy Speaker, I introduced this bill months and months and months ago, and the member for Melbourne could have come and seen me if it was so important and discussed it, and perhaps some stakeholder engagement could have been taken rather than being ambushed on the night that the bill was being finally summed up. Can I say to you that one of the key considerations in relation to all this is the Myriad case? Because, Deputy Speaker, the Myriad case is in a position at this point in time where there has been leave sought to appeal to the High Court, and we need to wait for that decision. That decision will come down sometime in the new year, but we don't want to preempt that decision. We want to have that finding, and understand exactly where it's at. As I said, Deputy Speaker, this bill was never intended to address the issue of the gene patents debate. Many speaking on this bill have raised it, but it was never intended or designed to address the gene patents debate. As you would be aware, Deputy Speaker, in September this year, the full bench of the Federal Court of Australia released its decision in the Darcy versus Myriad Genetics Incorporated case. And shortly after, the application for special leave to appeal this decision was lodged with the High Court. The decision of the full Federal Court that isolated gene sequences are patentable affirmed the existing practice in Australia of granting patents for biological materials which are new, inventive and useful. I want to be very, very clear here, Deputy Speaker, that genes in their natural state in the human body are not, never have been, patentable in Australia. And most of our major trading partners share the same approach to allowing these gene patents. Europe, Canada, New Zealand, Japan, China and Korea all grant patents for isolated gene sequences. The United States, Deputy Speaker, is out of step with many other developed countries because of a decision by the United States Supreme Court back in 2013 that found that isolated gene sequences were not patent eligible. Let me be clear here also. The US law is no way binding on Australian law. Let me restate that for the record. US law is no way binding upon Australian law. The United States is still coming to grips with that 2013 decision, and it's not clear what impact it will have on the investment in biotechnology and medical sectors. Madam Deputy Speaker, the Australian government has always been conscious of balancing the needs of innovators whilst upholding the competitiveness of the Australian research and development industry. As I said, Madam Deputy Speaker, the government is considering the implications of the full Federal Court decision. However, until such time as we know the outcome of the High Court leave application, any legislative amendments in relation to gene patents would simply be premature and, as I said, are not a part of this bill. To conclude, Madam Deputy Speaker, the intellectual property system is vital to the strength of Australia's economy because it encourages invention and investment in new technologies, products and markets. This bill helps to ensure that we have an efficient and streamlined intellectual property system, and it's an important step forward in reducing the red tape and regulatory costs for Australian businesses. And, Madam Deputy Speaker, that's what's critically important. I commend this bill in its original form to the House.
Thank you. The question is the bill be agreed to. All those in favour say aye. Those against? I beg your pardon. The question is that the bill now be read a second time. All those in favour say aye. Aye. Those against? No. I think the ayes have it. The clerk.
Second reading, a bill for an act to amend legislation relating to intellectual property and for related purposes.
The House will now consider the bill in detail, and I understand it's the wish of the House to take the bill as a whole. The question is the bill be agreed to. Call the member for Melbourne.
Thank you, Deputy Speaker. I ask leave to move amendments 1 and 2 as circulated in my name together.
Is leave granted? Okay, member for Melbourne has
I
the call.
move amendments 1 and 2 as circulated in my name together. Deputy Speaker, I canvassed the reasons for these amendments in my second reading speech, and I won't go to them again in detail. But the point is simply this: these aren't amendments that are about whether or not the human gene or parts of it or parts of the genome are patentable. This is an amendment that arises out of extensive Senate and other inquiries into this legislation and other attempts to amend this legislation. And what it does is address the issues that both patients have raised about the difficulty of accessing Crown use provisions and getting ministers to make decisions, and the issues that companies have raised about how they sometimes feel that Crown use the capacity for Crown use provisions to be exercised can work against them commercially. So what it does is, without altering the Crown use provisions in the Act, sets out a process whereby people such as the patients who commence proceedings that are now ending up in the High Court, as the Minister referred to, potentially ending up in the High Court, as well as anyone else in the future, now has a known process for approaching the Minister, and the Minister has a process for determining whether or not to exercise the Crown use provisions, because, as has been heard, complaints have been raised from both sides. Because those provisions are so infrequently used, neither side feels that they are being properly exercised or that their concerns are being properly addressed. So these are sensible amendments that also attempt to ensure that within the definition of services there's some clarity about the definition of services, and that it includes research that's primarily funded by the Commonwealth, so that the Commonwealth is in the position to ensure that there is no limit on research that's conducted in this country and that innovation is encouraged. So for those reasons and the reasons that I've expanded upon in my second reading contribution, I commend these amendments to the House.
The question is that the amendments be agreed to. Parliamentary Secretary.
Well, thank you, Madam Deputy Speaker. I won't delay the House any further. We will not accept these amendments on this basis. There is no consultation. And the reason they were rejected in the original bill was a lack of consultation between industry in particular. And if you want a bill like this to succeed, the member for Melbourne should perhaps detail to the House how much industry consultation he's actually performed before moving this amendment. I think it's incumbent on people, when they move amendments, they do it on a basis of fact and engagement with stakeholders, so there is some substantial effort and understanding of what they're trying to achieve. I am not saying that Crown use provisions are bad, but as it was outlined when the bill was originally introduced by the former government, there hadn't been enough stakeholder engagement. There was a negative reaction from industry which needed to be overcome. We will go through the processes of time and look at Crown use provisions into the future, but not just now. And for those reasons, because this is rushed, and as I said, the first I'd heard about an intention to move this amendment was here tonight when I walked into the chamber. I would have thought that if you wanted to get an amendment like this up, rather than a bit of grandstanding, one might have come and seen the government put forward the case and the need and the reason and put the case forward. So we will be rejecting this, so I move that the amendments be rejected. Sorry.
The question now is that the bill be agreed to. All those in... Sorry, I beg your pardon. The question is that the amendments be agreed to. All those in favour say aye. Those against no. I think the noes have it. The question now is that the bill be agreed to. All those in favour say aye. Those against no. I think the ayes have it. Parliamentary Secretary? So the bill has now been agreed to. I call the Parliamentary Secretary.
Madam Deputy Speaker, I ask leave of the House to move the third reading immediately.
Is leave granted?
I move this bill be now read a third time.
I call the clerk. The question is that the bill be now read a third time. All those in favour say aye. Those against no. Call the clerk.
Third reading, a bill for an act to amend legislation relating to intellectual property and for related purposes.